Dinner's half eaten when the dogs start up. You go to the window, flick the porch light on, and there are two of them already standing on your gravel. Not at the gate, past it. Past the chain, past the sign you screwed to the post yourself. One of them lifts a hand, friendly as anything. "G'day, mate. We just want a quick chat." That's not curiosity. That's a trained man who needs permission and is hoping you'll never work out that he needs it, because the moment you invite him in, he stops needing anything else from you at all. In February 2023, a judge of the New South Wales Supreme Court held that officers who climbed a locked gate past exactly those signs were trespassers. Nobody told these two. So you open the door, because that's what decent people do. And that's the part that cost you. Look where that sign is now, behind them, facing the road, facing nobody, doing its job for an audience that's already walked past it. You put it up believing it was a wall. It isn't. In this country, it's one sentence in a conversation about permission, and almost nobody who owns one knows what it says. Here's why. Australia has no Fourth Amendment, no constitutional right to privacy, nothing you can hold up at a gate. What we have instead is older and stranger. The High Court put it plainly in Plenty versus Dillon back in 1991, when police walked onto a South Australian farm to serve a summons. The court held they had no right to be there. Every invasion of private property, however small, is a trespass. That's the foundation. Not a right against searches, a right against entry, which changes the question you're standing there asking. It's never, have they got grounds? It's two separate questions. Have they got permission? And if not, have they got a power? Your sign only touches one. So before anything else, you need to know which door these two came through. Your hand's on the door handle. Here's what the next 4 seconds are worth. You step outside to be polite. The chat becomes an interview. The interview becomes a reason to be inside. And by morning, what you volunteered on your own driveway is the account they'll test everything else against for a year. That's the ladder. 4 seconds to the first rung. Here's my promise. One calm sentence said at the door that protects your position without a word of defiance in it. And a second thing you need more than the sentence. There's one moment tonight where refusing is itself the offence. I'll show you exactly where that line sits. Quick word on what this is. Plain English Australian law, checked against the statutes and the judgments. Every case name and section number in the description. New South Wales is the spine here, and I'll flag Queensland and Victoria where they part company. Getting the state wrong is the one mistake that actually hurts you. And I won't pretend officers are the enemy. Most are professional and well trained. That's exactly why you prepare for the two on your gravel who aren't. We start where every honest version has to start. Musts, before anything you're allowed to refuse. If they have a lawful power to be there, your sign is scenery, and getting in their way is a crime. In New South Wales, hindering or resisting police under Section 546C of the Crimes Act 1900. And those powers are wider than you imagine. Under LEPRA, Section 10 lets police enter to arrest someone they reasonably believe is inside. Section 9 covers emergencies, a breach of the peace, or someone in imminent danger of serious injury. Part 6 goes further. Section 82 lets one resident's invitation carry them in. It can override another occupier standing there saying no. Queensland runs it through the Police Powers and Responsibilities Act. Sections 19 and 21 to inquire or arrest, 596 for a suspected death or injury, 609 to prevent domestic violence. Victoria sets the bar higher to enter a home. Victoria sets the bar higher to enter a home to arrest. Section 459A of the Crimes Act, 1958, needs a serious indictable offence. Now the limit that protects you. None of those powers get created by an officer deciding he'd like a chat. The High Court said it in Coco in 1994. Authority to trespass has to be spelled out in unmistakable and unambiguous language, never assumed. And no, there are no magic words. Nobody's a traveller on the land. Nobody is not consenting to be governed. And no notice nailed to a fence post makes you sovereign. That's not law. That's an extra charge and a much worse night. So if they haven't got a power, what were they relying on when they stepped over your chain? We're not here to give you grief, mate. Quick chat and we're gone. That's the friendliest sentence in policing. It's doing the heaviest lifting of the night. Because there's an unwritten permission slip attached to almost every house in Australia, and you've been renewing it daily without knowing. The High Court described it in Halliday versus Neville in 1984, where the path or driveway is left unobstructed, where the gate is unlocked and there's no notice forbidding entry, the law implies a licence in favour of any member of the public, including a police officer on duty, to walk up and knock for a legitimate purpose. Read that list again, because it's a checklist and most Australians fail all three. Unobstructed path, unlocked gate, no notice. Your driveway's open. Your gate swings. That's a licence you handed out this morning without knowing. And the wrong answer is the most natural one there is. Yeah, no worries, come up. Which turns an implied licence into an express one. One thing does limit it: purpose. In TCN Channel 9 against Anning, the New South Wales Court of Appeal found a television crew who came through an unlocked gate had at most permission to walk up and ask. Filming the raid was wholly outside it. That cost them $50,000. Which brings you to the question you clicked on. Does a sign end the licence? Before I answer, I have to tell you what the High Court said 5 years ago, because it's the opposite of what you're hoping. We're just doing a check. Won't take a minute. In 2020, the High Court decided Roy versus O'Neill. Police walked up to a unit door in the Northern Territory to check compliance with the domestic violence order. No locked gate, no signs, a perimeter fence, and an open approach. The majority held the implied licence stretched far enough to cover police coming to the door for lawful communication, including checking on someone. 3 judges to 2. Bell and Gagela dissented, and that matters. The point was close, not settled by acclamation. Here's what that means in your doorway. An officer walking up your open driveway to knock and ask questions is, in the ordinary case, doing something entirely lawful. Not a search, not a trespass, just a knock, carrying the whole weight of the state and needing none of the paperwork. So if your defence is, I've got a sign up, and your gate is open and the sign is small and faces the road and says nothing about police, you've almost certainly changed nothing. The wrong response hides in there too, arguing about a sign that never did what you assumed, while a notebook records you got agitated over a routine check. And note how that case ended. The breath test was admitted and the man lost. So what does end the licence? There's one Australian judgment that answers it properly, and it happened on a property outside Kyogle. The sign catches the light as they pass it. The 24th of August, 2021. 2 officers attend a rural property near Kyogle on information the owner might be organising a gathering. The gate is chained and padlocked. A sign warns against trespass without consent, and a second says admittance is by invitation only. and names police specifically. They climb the gate and walk to the house. On the 7th of February 2023, in Romani, against the state of New South Wales. Justice Wright of the Supreme Court found the implied licence had been impliedly refused by the locked gate and expressly revoked by the signs. With no other authority to be there, the officers committed trespass. 7,500 general damages, 5,000 aggravated, 5,000 exemplary, and appeared to have had no training on the limits of entering a property with a locked gate and signs displayed. So the recipe is 3 parts: a physical barrier, a clear sign, and the bit almost everyone misses: wording that names police, not just trespassers. Be honest about that judgment though, and appeared to have had no training on the limits of entering a property with a locked gate and signs displayed. So the recipe is 3 parts: a physical barrier, a clear sign, and the bit almost everyone misses: wording that names police, not just trespassers. Be honest about that judgment though. One judge, a civil claim for money, not the High Court, and not a ruling about evidence. Which brings us to the ugly half, because the sign working and you winning are 2 completely different things. Mind if we come in? Be easier than standing out here in the cold? Every question is a door, and each one you open unlocks the next. Where have you been tonight opens who are you with, which opens and what's in the shed. Nobody asks the 3rd question first. They ask the first one, and the second only exists because you answered. What goes in the notebook at each step isn't evidence. It's an account. Times, names, movements, in your own words, unchecked, at 9 at night, in your socks, in a doorway. And an account doesn't change afterwards, no matter what you remember on Tuesday. The doorway is a door too. Stepping onto the gravel to talk feels polite. It also puts you where they can see, hear, and smell everything about you. Then there's the response that ends the whole legal question in one breath. Come in. I've got nothing to hide. Consent is the cheapest key they'll ever be handed. Think what it saves them. No magistrate to convince, no grounds to establish, no warrant to apply for. All of it gone, because you were decent for 4 seconds. They don't need to satisfy a court if they can satisfy you. And here's where this turns genuinely nasty, because there's no version of this conversation where talking helps you. Talk a lot, and it reads as nervous, over-explaining. Story kept shifting. Say nothing, and it reads as evasive. Both fit in a notebook. The account gets written either way, and all you control is whether you're dictating it. Now, the video you watched last week about this was almost certainly American. Over there, the topic runs on the 4th Amendment. Florida versus Jardines 2013. Police may knock like anyone else, but the license has limits. Even there, the sign beats the knock claim is contested. In Carlos, a federal appeals court held no trespassing signs did not revoke it. The dissenting judge, Neil Gorsuch, before the Supreme Court, wrote that a homeowner may post as many no trespassing signs as she wishes. She might add a wall or a medieval-style moat too. That was the dissent. The majority went the other way. But here's the part that matters more than all of it. Over there, an unlawful search usually gets the evidence thrown out. Here it doesn't. Under Section 138 of the Evidence Act, improperly obtained evidence is excluded only if the court decides the undesirability of admitting it outweighs the desirability. That's the Bunning versus Cross Discretion, running since 1978. In Queensland, Western Australia, and South Australia, the common law does the same work. Plain English. Police can trespass on your land and a court can still let in what they found. The sign wins you a civil claim. It does not win you the case. We're close to the exact words now. But you need one more thing first, because saying them at the wrong moment is the mistake I promised you. Here's the sentence. Porch light on, 2 of them on your gravel. Your hand still on the door. You say this calmly once, and you stop talking afterwards. Officer, I'm not giving you permission to be on my property. If you've got a warrant or a power that lets you be here, tell me which one and I won't get in your way. If you haven't, I'm asking you to leave. Again, slowly. Officer, I'm not giving you permission to be on my property. If you've got a warrant or a power that lets you be here, tell me which one and I won't get in your way. If you haven't, I'm asking you to leave. Screenshot that. Say it out loud once tonight at your own door. Why each piece is there. I'm not giving you permission is the revocation. The Halliday checklist said out loud in the present tense with no accusation in it. It's what your sign was trying to do, done properly. The middle clause is the concession, and it carries more weight than the rest combined. It hands over everything the law makes you hand over, makes obstruction impossible to allege, and forces them to name a power. The last clause is the one that matters months later. In Kuru against New South Wales in 2008, the High Court held that once permission is withdrawn and a reasonable time has passed, police become trespassers. That case started with a man in his own flat asking officers to go, and finished in the High Court. The trial judgment in his favour was more than $400,000. Delivery matters as much as wording. Flat, polite, slightly quieter than they are. Be forgettable. Boring endings are the ones that end. And now they push, because that's the job. If you've got nothing to hide, why are we even having this conversation? You give the sentence back, unchanged, same flat tone. Officer, I'm not giving you permission to be on my property. If you haven't, I'm asking you to leave. Second push, sharper. You're making this a lot harder than it needs to be. It isn't, and he knows it isn't. Refusing permission is not evidence of anything, and no court treats it as such, but it's built to make you feel you've already done something wrong. Same words. That's 3 times now. Picture how this usually goes. Porch light, gravel, 2 of them halfway up the drive. G'day. Quick chat? Your sentence. A pause. We're just following something up. Same answer. One of them glances back at the gate, works out how they got in and says, no dramas. We'll be in touch. They walk back down the drive. None of that was defiance, just a bloke who'd have stepped aside for any real power and gave away nothing without one. But there's a fork past this point, and one arm of it is where refusing stops being your right and becomes your offence. One question resolves it all. Officer, what power are you here under? If they name one, an arrest under LEPRA Section 10, an emergency under Section 9, a domestic violence concern under Part 6, a warrant in their hand, you step aside. Fully. Immediately. You don't audit it on your own driveway at 9 at night, because that's the moment everything in this video stops working. Against a genuine power, the sign is scenery, the chain is scenery, the sentence is scenery. Standing in their way is hindering police. Section 546C in New South Wales. Obstructing a domestic violence entry warrant carries its own offence under Section 84 of LEPRA. That's the one place where refusing is the mistake. 3 edge cases. In Romani, the owner recovered. His daughter, living there without exclusive possession, had no standing to sue at all. If your name isn't on the title or the lease, your remedy may not exist. Wording works. No trespassers does less than a sign saying entry, is by invitation only, that names police. And the gate does more than the sign. A locked gate is a statement the law already understands. A sign on an open gate is an argument. Keep the number 2, $18,334. That's what the trespass was worth. 2 people never to become, the over-explainer and the driveway lawyer. The license, the gate, the sign, and the powers that beat all 3. I've gathered every one of them in a book called Know Your Rights, link in the description, waiting for the night you weren't expecting. Let's put it all together. Officer, I'm not giving you permission to be on my property. If you haven't, I'm asking you to leave. 2 things you can't refuse, a lawful power and a warrant. Your permission was never one of them. General information, not legal advice, and this is one area where the law genuinely differs between states. If they've entered, don't fight it on the driveway. Write down the time, the names, what was said, then ring a lawyer. Subscribe, not for luck, for the next knock, so nobody you love opens a door out of politeness and spends a year explaining it. But if they say the words welfare check, everything in this video changes, because that isn't a request, and there are states where it isn't even a knock. That video's on your screen now. Back on the gravel, the porch light's still on. The torch beam swings away down the drive and crosses your sign, this time from the right side of it. The chain goes back through the gate. The dogs settle. Your dinner's cold on the table, and there's nobody inside your house you didn't ask in.